The chamber of the Supreme Court grew quiet as Jasmine Crockett stepped up to the podium, her sharp navy suit contrasting vividly with the rich mahogany setting. The camera focused closely on her serene, assured smile, which stood in stark opposition to the heavy tension filling the space. Just minutes before, Justice Stephen Breyer had shocked everyone in the courtroom by cutting off the opposing counsel with a surprising remark. "I would like to listen to Representative Crockett's perspective." The legal insights in her brief were outstanding. The conservative justices fidgeted uncomfortably. Chief Justice Roberts arched an eyebrow, yet what came next created waves across the legal community. While Crockett flipped open her case file, Justice Breyer inclined forward and uttered phrases nobody anticipated from the 83-year-old judge. "Congresswoman, your view on the Constitution questions long-standing precedents in manners I find impossible to ignore. Kindly elaborate for my fellow justices." Whispers broke out in the gallery until the officers re-established calm. Crockett remained resolute and composed, ready to present a case that would quiet doubters and permanently alter the court's perception of this emerging congresswoman from Texas. Prior to exploring this remarkable event further, remember to hit like and subscribe for up-to-date political breakdowns and Supreme Court updates. Representative Jasmine Crockett was familiar with intense legal confrontations. Prior to her congressional election, she had built a strong name as a civil rights lawyer in Texas, tackling cases others deemed impossible to win. Her rapid ascent from the Texas state legislature to the U.S. House stemmed from popular video snippets of her incisive interrogations and her skill in breaking down intricate legal matters for everyday people. However, this particular appearance differed from all previous ones. The dispute revolved around voting rights limitations that unfairly impacted minority groups, a trend Crockett had battled throughout her professional life. For several weeks, right-leaning outlets belittled her as novice and unfit to contest established legal norms. "She's just a first-term congresswoman pretending to be an attorney at the Supreme Court," sneered one pundit. "Breyer will demolish her." Justice Stephen Breyer, in his last term prior to stepping down, had forged a reputation as a practical liberal concerned with the real-world application of laws. Renowned for his profound inquiries and scholarly depth, his impact had molded American legal doctrine over many years. Yet that morning, onlookers spotted a change. He seemed to be examining her intently. Court journalist Nina Totenberg later noted that her brief appeared dog-eared, marked up, and covered in his personal annotations. Not many knew that Crockett had devoted months to developing a fresh legal concept that contested recent voting rights judgments without outright criticizing the conservative justices behind them. Pulling from neglected principles from the Reconstruction period and archival documents, her position was innovative yet firmly rooted. The implications were massive. The voting access of millions of Americans was at stake. A loss would allow restrictive regulations to persist, influencing elections for a long time. Conservative advocacy organizations submitted friend-of-the-court briefs, labeling her ideas as hazardous and extreme. While Crockett organized her documents, Justice Samuel Alito bent toward Justice Thomas and murmured something that elicited subdued grins. Justice Barrett drummed her pen restlessly. Breyer's gaze alone stayed locked on Crockett, as though he perceived what his peers had overlooked. "Congresswoman Crockett," started Chief Justice Roberts. "You are allotted 30 minutes for your presentation. I note that this court has dealt with these matters not long ago. The precedent is evident." Crockett acknowledged with a nod. "Thank you, Mr. Chief Justice. Indeed, I know the court's precedents well. That's exactly the reason for my presence here today." The scene was prepared for a clash unlike any the Grand Chamber had seen in recent times. Crockett proceeded evenly, her voice measured and intentional, distinct from the passionate delivery observed in committee sessions. "Justices," she declared, "I draw your focus to Section 2 of the Voting Rights Act, which this court has earlier construed as demanding evidence of discriminatory purpose instead of just discriminatory effects." Justice Alito cut in nearly right away. "Congresswoman, that's resolved doctrine from merely 2 sessions past. Do you seek for us to reverse our own ruling?" His voice held a subtle disdain. Crockett held steady. "No, Justice Alito. I request that you implement it accurately." She revealed a paper not included in the primary submissions. This statistical review wasn't accessible in the prior case. It illustrates that even by your criteria, discriminatory purpose is apparent in a trend accountable solely to race. The strain intensified, confronting Alito head-on was daring. Spectators traded looks. Was this a show or a genuine legal advance? Then, unusually, Justice Thomas voiced a question. Congresswoman, such data might be interpreted variously. Why is your view the accurate one? Before Crockett answered, Justice Breyer stepped in. In fact, Justice Thomas, the approach matches what this court endorsed in Johnson v. United States in 1987. It's valid. Facing Crockett, he continued, proceed, Representative. The interaction was exceptional. A liberal justice seemingly protecting a congresswoman from conservative examination. Journalists jotted notes rapidly. A pivotal event was developing. Crockett advanced, constructing her case incrementally. She referenced obscure precedents, prompting the justices to leaf through their documents for checks. When Justice Barrett disputed her take on a 1980s ruling, Crockett countered by citing Barrett's personal law review piece from her scholarly period, one that backed Crockett's position. Silence enveloped the chamber. Even detractors had to concede that Jasmine Crockett had not merely grasped the law, she had reinvented its presentation at the country's top tribunal. Justice Barrett, I recall you stated in 2006 that patterns of statistics on this magnitude establish a presumption shifting the onus to the state to demonstrate absence of discriminatory purpose. I'm merely utilizing your academic structure on these details. Barrett appeared briefly taken aback, obviously not expecting her scholarly output to appear in this setting. The courtroom's tension mounted as Crockett methodically unraveled each conservative contention. She avoided camera appeals or emotional reliance. Her method was systematic and profoundly analytical, revealing a degree of legal accuracy few had foreseen. Justice Kavanaugh adopted a new strategy. Congresswoman, assuming we endorse your statistical review, doesn't the state possess a vital interest in curbing voter fraud? These steps seem precisely designed for that goal. It was a calculated query meant to trap Crockett into appearing indifferent to election security issues, a story conservative outlets would probably highlight that night. The crowd hushed, anticipating her reply. Crockett offered a subtle smile. Justice Kavanaugh, I'm pleased you mentioned that. She grabbed another paper. I've examined all voter fraud cases in this state across the last 20 years. There were precisely 13 instances, and none would be averted by these policies. She halted momentarily. Yet, these rules would prevent roughly 740,000 qualified voters from participating. If narrow tailoring is the topic, I'd argue this is quite the reverse. Justice Breyer gave a faint nod. The conservative justices shared looks. As Crockett's allotment approached its close, Chief Justice Roberts, silent until then, finally commented. Congresswoman Crockett, your statistical work is persuasive, but this court has shown reluctance to meddle in state voting operations absent an obvious constitutional breach. It was the chance she had expected. Chief Justice, I appreciate the court's prudence, Crockett responded calmly. Which is why I've reserved my strongest point for the conclusion. She unlocked her briefcase and revealed a compiled historical archive unknown to the justices. This is a freshly discovered record of congressional discussions during the 15th Amendment's creation. It contains declarations from the amendment's creators directly tackling the state actions relevant today. The justices seemed astonished. Materials from that time are scarce, and recently validated records illuminating original intent are regarded gravely by the court. I've secured verification from historians at 3 institutions. Crockett went on, it reveals that the 15th Amendment's framers deliberately aimed to halt states from enforcing procedural hurdles that unevenly hindered newly emancipated citizens' voting rights, even if those statutes avoided explicit racial mentions. Justice Breyer bent forward. Congresswoman, may I examine that record? He inquired. Crockett agreed, handing it to the clerk who delivered it to the bench. The mood tensed again. She had saved this disclosure for the final instance, a tactic that might either bolster her position dramatically or appear as a desperate ploy. Breyer inspected the record meticulously, his demeanor evolving from interest to clear involvement. The other justices observed intently, evidently disturbed by the surprise proof and Breyer's response. Justices, Crockett stated, as the red indicator showed her time was up. I think these documents supply the exact constitutional basis the Chief Justice mentioned. The 15th Amendment's framers anticipated this precise problem and deliberately moved to block it. Typically, the Chief Justice would express thanks and end the proceeding, but now Justice Breyer intervened. Mr. Chief Justice, he remarked, I think the court would gain from granting the Congresswoman extra time to detail this historical proof. It strikes me as truly remarkable. Silence blanketed the courtroom. Additional speaking duration is seldom allowed, particularly upon a justice's suggestion. Every eye shifted to Chief Justice Roberts, whose reply would reveal the court's regard for Crockett's case. Roberts paused shortly before assenting. 5 more minutes, Congresswoman, he declared. Concentrate solely on linking this historical record to our present legal doctrine. As Crockett launched into her prolonged comments, the legal reporters there grasped they were observing something outstanding. The courtroom's atmosphere had transformed. The Congresswoman, formerly undervalued by skeptics, now commanded the focus of the nation's premier judicial authority, with one of its esteemed justices publicly backing her rationale. No one could have predicted the ensuing developments. Poised at the podium, Crockett regarded the added 5 minutes as a sudden chance. The historical record she introduced had evidently captured Justice Breyer's attention, although the other justices stayed wary, some curious, others skeptical. Justices, please turn to page 37 in this congressional archive, Crockett started, her delivery even and purposeful. Senator Charles Sumner, a key designer of the 15th Amendment, declared, the amendment should not just prohibit overt racial obstacles to voting but must authorize Congress to tackle indirect tactics that yield identical outcomes via procedural methods. Flipping the page, she proceeded, and here, Representative Thaddeus Stevens elaborates more. A state might assert neutrality, like fraud prevention, but craft policies that disproportionately encumber freedmen. The amendment must counter such dodges. Justice Thomas inclined forward. Congresswoman, although this background is intriguing, how do these assertions modify our evaluation when this court has repeatedly ruled that disparate impact by itself does not nullify election statutes? It was the instant Crockett had readied for, the chance to convey her central contention. Justice Thomas, that's exactly why these materials are essential, she answered. The 15th Amendment's framers did not restrict their scope to blatant racial bias. They purposefully accounted for voting processes that, despite facial neutrality, imposed unequal loads. She paused, locking eyes with each justice. But I'm not requesting the court to depend only on disparate impact. These archives indicate that the 15th Amendment's original comprehension encompassed what we could now term a burden-shifting method. Once specific statistical levels are met, Justice Breyer's eyes broadened a bit as he turned to a part he had noted. Congresswoman, he questioned, do you mean Senator Howard's comments on page 42? Crockett grinned. He had located it independently. Precisely, Justice Breyer. Senator Howard suggested that if a voting process reduces involvement among black voters by over 1/3 relative to white voters, the state must establish a vital and essential rationale. This mirrors standards the court employs already in other constitutional areas. Justice Barrett interrupted. But Congresswoman, supposing we agree this embodies the original intent, the court's legal doctrine has advanced over 150 years. Are you proposing we discard settled precedent? Certainly not, Justice Barrett. Crockett replied fluidly. This historical proof demonstrates that the court's contemporary structure has strayed from the 15th Amendment's initial significance. Realigning with that base would render the court's voting rights doctrine more unified. She then displayed a graph from her legal submission that hadn't been addressed yet. This information shows that using the original view would influence only a limited group of voting statutes, namely those causing the gravest disparate effects. Most election rules would stay intact. Justice Kavanaugh, noticeably restless, changed approaches, readying another query sequence. Congresswoman, even assuming your historical examination is compelling, what's the restricting guideline? One justice inquired, would this method nullify every voter ID statute? No, Crockett answered assuredly. Only those hitting the statistical mark and where the state fails to show a necessary and vital objective. Numerous voter ID statutes would endure this review if states offer free IDs and guarantee equitable access. She was evidently ready, foreseeing each inquiry before it turned into a barrier. The gallery observed as Crockett systematically handled and deconstructed each challenge. Chief Justice Roberts, recognized for favoring limited decisions over broad ones, bent forward. Couldn't we resolve this matter more restrictively without reassessing our whole voting rights structure? It was the sort of query that often indicated his pursuit of a compromise solution. Crockett capitalized on it. Mr. Chief Justice, indeed, the court could pursue that path. The statistical proof alone, under current precedent, justifies a decision supporting us. Yet, she added, I would humbly propose that the historical archive gives this court a chance to introduce clarity and unity to a legal domain that has grown disjointed and challenging for inferior courts to enforce reliably. Then arrived the instant that hushed the courtroom. Justice Breyer, who had been diligently assessing the historical items during Crockett's presentation, shut his folder and gazed at his peers. I've dedicated almost 3 decades to this court attempting to grasp the original essence of our Constitution's safeguards for voting rights, he commenced, his words echoing in the chamber. And I have to admit, across all my tenure, I've seldom come across historical proof this convincing on this specific matter. The declaration lingered. Breyer, generally noted for pragmatic over originalist logic, was supporting Crockett's historical case using originalist terms, speaking straight to the conservative justices in their judicial idiom. Congresswoman Crockett has not merely revealed a previously ignored historical archive, he supplemented, but she's illustrated how it integrates into our current legal structure without triggering the judicial upheaval some could dread. Justice Alito, evidently uncomfortable with Breyer's remarks, interposed, "Justice Breyer, are you implying we reverse our ruling from only 2 terms back based on a record not even part of the initial submission?" Before Breyer responded, Crockett answered serenely. "Justice Alito, if permitted, I'm not urging the court to reverse that ruling. That matter centered on requiring discriminatory purpose. The court affirmed yes, and I embrace that precedent." Her delivery was consistent but conveyed strong belief. "What I'm demonstrating is that the statistical trends here fulfill the intent criterion when evaluated correctly. The historical archive merely offers constitutional backdrop for why that structure is right." Breyer nodded in approval. "Precisely, Justice Alito. We wouldn't be reversing precedent. We'd be employing it with a deeper grasp of the involved constitutional clause." The courtroom's vibe had completely altered. What started as a standard presentation by an undervalued congresswoman had evolved into a virtuoso display of constitutional logic. One of the court's most admired justices now publicly endorsing her method. As her duration wrapped up, Chief Justice Roberts addressed her, his manner noticeably more deferential than earlier. "The court appreciates your comprehensive delivery." Congresswoman Crockett collected her items, shared a quick look with Justice Breyer, who gave a discreet nod of esteem, and went back to her place. The opposing counsel, gearing up to present next, appeared clearly rattled. The state's lawyer had anticipated rebutting conventional voting rights claims, not a historically anchored originalist argument now affirmed by Justice Breyer personally. In the media area, reporters hurried to dispatch reports to their superiors. Something extraordinary had transpired, and the headlines were forming already. Breyer backs Crockett's revolutionary constitutional claim, surprising partnership on voting rights. What transpired following the oral arguments within the justices' confidential meeting room was even more astounding. 3 days afterward, the Supreme Court's Communications Office released an unusual statement with extensive consequences. The justices had solicited extra briefs regarding the historical proof offered by Congresswoman Crockett. Constitutional experts from various ideologies quickly identified the action as exceptional. The court infrequently seeks further details post-oral arguments, and when it occurs, it typically indicates a possible adjustment in the justice's case strategy. Behind the Supreme Court's sealed doors, Crockett's display was echoing through the elegant corridors. Per anonymous sources, the justices' after-argument meeting was exceptionally strained. Justice Breyer was unusually assertive, one source disclosed. He informed his peers that overlooking Crockett's historical proof would constitute the utmost intellectual deceit, a bold assertion from a justice famed for his amicable demeanor. Simultaneously, on Capitol Hill, Congresswoman Crockett came back to discover her office swamped with press inquiries and endless calls. CNN, MSNBC, and surprisingly Fox News vied for discussions. In a flash, her social media audience surged, with #JasmineConstitution gaining traction countrywide. "I merely laid out the facts and the law," she informed journalists outside her workspace. "The Constitution isn't owned by a single party or belief system. It serves all Americans. Its safeguards should extend to each voter, irrespective of race or location." At first, conservative analysts tried to minimize Crockett's showing. "Theatrical politics from a novice congresswoman," proclaimed one Fox News anchor. However, legal authorities spanning ideologies saw it otherwise. Harvard's Alan Dershowitz, far from a liberal advocate, informed CNN, Congresswoman Crockett delivered a superb fusion of archival inquiry and constitutional logic. "The court will struggle to dismiss proof this strong." Notable conservative thinker Randy Barnett posted on X, "As an originalist, I consider the recently revealed 15th Amendment discussions captivating and possibly crucial for our grasp of voting rights doctrine." Within the court, views diverged. Justice Thomas, who had first brushed off the claim, directed his clerks to confirm the validity of Crockett's materials and explore their historical setting. Justice Barrett, whose academic output Crockett had referenced, was apparently revisiting the statistical information through the historical lens. 2 weeks post-oral arguments, Justice Breyer made a surprise showing at a judicial gathering at Yale Law School. Though Supreme Court justices usually steer clear of pending case talks, Breyer discussed constitutional analysis in general terms. Occasionally, he remarked, fresh proof or examination can contest our fixed comprehension. When that arises, intellectual integrity requires us to evaluate if our precedents have veered from the Constitution's authentic essence. This concerns fidelity to law, not politics. All present grasped the implication. Without referencing Crockett or the dispute, Breyer indicated her points deserved earnest review. The political repercussions expanded. Voting rights entities supported Crockett, initiating a countrywide effort called Stand with Jasmine to underscore the case's value. Civil rights associations organized prayer gatherings outside the Supreme Court. Ex-President Barack Obama commended her astute and ethical representation in a viral post. On Fox News, Representative Jim Jordan faulted Crockett's efforts, terming them yet another radical left bid to nationalize elections. But when urged to tackle the particular historical proof she introduced, Jordan paused, conceding, "I haven't examined those materials myself." 3 weeks following oral arguments, the narrative advanced significantly. The Washington Post released an in-depth probe verifying the genuineness of Crockett's historical items. They originated from a formerly unindexed collection linked to Frederick Douglass, who had participated in multiple original congressional talks on the 15th Amendment. The Post's title stated, "Crockett's Explosive Proof Authenticated by Experts." That very day, in an uncommon departure from court norms, Justice Clarence Thomas addressed a Federalist Society gathering. Without citing the case, he stressed the value of original comprehension in constitutional analysis. When distinct historical proof discloses a constitutional clause's original public sense, he declared, judges bear an obligation to synchronize their views with that comprehension, even if it demands reassessing precedent. Legal watchers were stunned. Was the court's staunchest conservative justice hinting at receptivity to Crockett's position? Conjecture heightened in the legal sphere. 45 days after oral arguments, the Supreme Court declared it would issue its verdict the next Monday. The prolonged interval between argument and verdict implied intricate opinions were under preparation and that alignments might have changed amid discussions. The evening prior to the judgment, Congresswoman Crockett featured on 60 Minutes. Speaking composedly, she noted, "No matter the court's choice tomorrow, I think we've already reshaped the country's dialogue on voting rights. These aren't theoretical legal ideas. They decide if millions of Americans can practice their core democratic entitlement." Monday dawn came with throngs assembling outside the Supreme Court well before the scheduled announcement. Media outlets positioned along the stairs for real-time reporting, and SCOTUS blog faltered from the flood of users updating for news. At exactly 10 a.m., Chief Justice Roberts started reciting the majority view. In a 6-3 ruling, the court sides with the petitioners, he proclaimed, triggering astonishment in the courtroom. Crockett had not only triumphed but also convinced at least one conservative justice to align with the majority. As Roberts proceeded, the legal world tuned in closely. He clarified that although the court had formerly mandated evidence of discriminatory purpose to strike down voting methods under the 15th Amendment, the historical proof here offered key context for assessing such purpose. Roberts unveiled a fresh structure. When data statistics reveal a substantial disparate effect on minority voters, the onus moves to the state to confirm its voting methods advance a vital governmental aim. This method, he observed, harmonizes with both precedent and the 15th Amendment's original grasp as shown in its congressional discussions. Justice Breyer presented a concurring view from the bench, a distinction for notably important decisions. Today, Breyer asserted, the court illustrates that devoted constitutional analysis isn't limited to a single judicial approach. Representative Crockett's remarkable archival work and legal logic remind us that the Constitution's voting rights defenses are meaningful, not just formal. Surprisingly, Justice Barrett penned a distinct concurrence, supported by Justice Kavanaugh. The petitioner's statistical structure, Barrett composed, when examined with the 15th Amendment's historical insight, delivers a practical equilibrium between state control over elections and the essential right to vote without discriminatory obstacles. Justice Alito crafted the dissent, backed by Justices Thomas and Gorsuch. The decision today marks an unjustified deviation from precedent, he contended, depending on historical proof that, though notable, shouldn't supersede entrenched doctrine. As the ruling's news circulated, Crockett's phone rang incessantly. President Biden called personally to commend her on the landmark success. Civil rights figures celebrated it as the decade's most vital voting rights ruling. Law institutions promptly incorporated the case into their constitutional curricula. When Crockett stepped out from the courthouse, crowds of backers burst into cheers. Journalists shouted queries, but she lifted her hands to address them. Today, the Supreme Court confirmed what ought never to have been questioned, she stated resolutely. The Constitution shields each American's voting right, irrespective of race, and forbids states from creating setups that suppress that right beneath impartial wording. Her voice grew firmer as she went on, this triumph isn't solely mine. It pertains to every person whose ballot was threatened. The senior voter lacking a reachable DMV. The employed parent unable to endure an 8-hour queue. The student whose university voting site was shut. That night, back in her congressional workspace, Crockett discovered a handwritten message awaiting her. She instantly identified Justice Breyer's unique script. Representative Crockett, it stated, over almost 3 decades here, I've seldom seen advocacy that so fluidly merges historical perception, constitutional tenet, and pragmatic discernment. You've altered not merely this dispute but possibly voting rights law's trajectory for eras. The Constitution and the country are fortified by your representation. With esteem and regard, Stephen Breyer. Crockett neatly folded the message and stored it in her desk. Then she addressed her team and declared, we've secured a skirmish, but the struggle for voting rights persists. Back to business. In the ensuing months, the ruling's effects spread through the legal and political arenas. States holding restrictive voting statutes hurried to modify their frameworks. Academic journals issued thorough examinations of the court's novel criterion. Constitutional educators developed fresh studies rooted in Crockett's contentions. Most strikingly, Crockett emerged as a nationwide icon, cited as a prospective Supreme Court candidate and highly desired for her constitutional knowledge. The first-year congresswoman, once brushed off as green, now conducted advanced seminars on advocacy at premier law institutions. A year on, Justice Breyer declared his retirement. In his parting words, he alluded to the voting rights matter. Even following decades on the bench, we jurists can acquire novel insights. He remarked, Representative Crockett showed me that constitutional analysis demands both intellectual modesty and ethical bravery. Her representation will stand as a pivotal highlight of my judicial path. When a journalist subsequently questioned Crockett on Breyer's statements, she grinned. Justice Breyer demonstrated that the Constitution isn't static, yet its fundamental safeguards last. She commented, when exceptional intellects analyze it with sincerity and uprightness, as he consistently did, justice triumphs. I'm simply thankful to have offered a case deserving of his wisdom and values. The tale of Jasmine Crockett and Justice Breyer would be examined for ages. A testament that in the American framework, one proponent with the proper contention at the apt instant can redefine constitutional legacy. Thank you for viewing this extraordinary account of how Jasmine Crockett's commitment and legal acumen gained Justice Breyer's admiration and forever changed voting rights. Remember to like and subscribe for additional uplifting narratives of justice and constitutional landmarks. Activate the notification bell to ensure you catch our newest reports on those safeguarding America's essential freedoms.